Hello, hello. Welcome to Uprise Music Production. This day we bring you our first episode. We want to try to define what is intellectual property. I've got two wonderful guests with me, and I would want them to introduce themselves and then start. Let's begin first.
My name is Megs. I'm a recording artist and I'm a public relations with marketing student from Ghana Institute of Journalism. I'm one of the guests on here today.
That's great. And you too?
My name is Philip Niwang. I'm a musical artist, a film director, a blogger, and also work with artists here under the music distribution company Uprise Music.
That's great. All right. So, for our viewers and listeners out there, our session is basically going to look at what is intellectual property, and I will present and I will ask you to take notes so that if you have some questions, you can also ask your questions. And then our viewers can also send their comments on their platforms and then all social media handles of Uprise Music. So that we would also take your comments and answer. And if you want a specific topic to be treated for you, you can also write it and then we'll begin. Are we good to go?
Definitely.
Are we good to go? All right, so let's start then. Understanding the basics of intellectual property. So when we say intellectual property, the word intellect means our minds and how we are able to use it to create things. And the word property in law simply means that any object which you value it and therefore you wish to protect it. And so intellectual property means mind creativity properties. We all know that we can use our money to buy cars, build houses, and do a lot of tangible things that we can hold with our hands. And so therefore, when somebody ventures into it in terms of trying to steal or take possession, you want to seek legal redress to be able to make sure that you protect that property. But when it comes to intellectual property, it is intangible. You cannot be able to hold it. For example, you have an idea and you have written a movie. You can't be able to hold this is the movie until it is produced onto or fixed into a CD or on a pen drive or any retrievable medium that you'll be able to say that this is a property. For example, another example can be music. If you create music, you have used your mind to create that music. But until that music is recorded and put it onto a CD, cassettes, on the streaming platforms and all that, you will not be able to hold it. And even when it is done, still, when you hold it, that expressive aspect of it will not be felt. And so these are intangible. You cannot hold them. That is why we call them intellectual property. And we have basically about three types of intellectual property. We have what we call trademark, which is a trademark or service names. They are all intellectual properties. We have patent, which are inventions granted to devices that are able to make our industry work more easily and more accessible. And then also we have copyright and related rights. So that is the three definitions that I would give, the three types. But basically, we can also put them into two main categories. We have what we call the copyright and related rights, and then the industrial property. So the industrial designs and copyright and related right, these two basic categories or the three types that we can talk about. Right, so today our focus will be on examples, and we want to find out that if we say an intellectual property, how do we protect it? One, for trademark, for example, Uprise Music, the spelling is APPRISE, and then music MUSIC. Right, so once you create this name and then you design it, it becomes a name. So we call it a service name, but it's a trademark under the Ghanaian, what they call it, Trademark Act, or the Intellectual Property Trademark Acts of various countries. So once you have that name, how do you protect it? In Ghana, you need to go to the Registrar General's department. You go to Registrar General's department, and then watch. The first process is to go and search. When you search, it's available. It means nobody has come to register it. So when you search and it is unavailable, it means somebody has already registered it first. And that is what it means by available and unavailable. So when you search and it's available, then you have to pick a form and pay for the name to be able to reserve for you. And so when you pick that form, you write the way you want it to be written. It becomes a service name or a trade name. Then if you see Uprise Music, the way it has been designed with some zero and something like a quaver representing the A and the PP and the RISE and the MUSIC, which is the same spelling as the word music. Then you design it in this kind of format, like our logo showing on the screen. This design then becomes a trademark, a mark that will put on any product. When it goes out, somebody will say, oh, okay, this product is made by Uprise Music. So Uprise Music can even make cameras and put Uprise Music logo on it, and it becomes a product from Uprise Music. They can make televisions, they can make movies, they can make any product, and once you see that mark on it, it becomes what? A trademark of Uprise Music. And so therefore nobody else can also make a similar video, film, or whatever and still put that logo on it. When you do, then you are infringing on Uprise Music product. Right. So that is trademark. And then the next one we want to also look is patent. Patent basically means that you have an idea. This microphone that I'm talking in, somebody's idea. Oh, we can speak. Everybody can hear us. But let's have a device that will help us be able to transmit the voice that I'm speaking to a large audience of people, or even go beyond where your normal voice can reach. And so that device, in the making of that process, it is known as a patent. So it becomes an invention. If it never existed and you have done it, then it becomes an invention that you have to seek what they call protection for it. So how do you protect patent? Patent is protected by going at the same time to the Registrar General's Department office. And when you are there, all you need to do is to go with what we call inventive steps. And sometimes it's quite difficult to do that. So you need a lawyer or you need a consultant who would be able to direct you how to write your inventive steps to be able to meet for patent grant. So once you're able to do that, you need to come along with designs or a diagram to show that this cable will connect here, this will pass here, this is how it will look, blah, 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 and all that. If you're able to do that, and then you do the steps. The steps is, number one, this device is called Uprise Music. And this device, the first thing is going to do this, second is going to do that, third is going to do this. This is how we create it. You buy this transistor, you buy this diode, you buy this ohms, you buy this, you buy that, you fix it this way, you fix it that way, you fix it that way. And then in the end, this is how it will look like with a diagram, and then it shows. And so once you are done, then this becomes your inventive steps. Then Registrar General's Department will take it, vet it. When they approve it, then they will grant you the patent. If you don't do and you bring the product out, you have within 2 years, by law, you have within 2 years to be able to make sure that you have filed. If you don't file after 2 years and somebody goes and file for that patent, you cannot retrieve that idea because it has gone from your hands. So that is how patent is protected. Then also the copyright, which is also, let me pick the designs. Designs here simply means that the outward appearance of any device. I can see you are holding a mobile phone. You're also holding a mobile phone. I'm also holding one. The outward appearance of this phone or device that you have in your home should be unique and not be similar to another product. So, for example, cars that we have, they have designs. Houses that we have, they have designs. All those designs falls under intellectual property category of designs. We call them industrial designs. So an architect built a house, he designed that house. And therefore, he wants to protect that kind of design and says that nobody else should be able to make such a design anywhere in the world. So he goes and register, and then he gets that. For example, if you look into Ghana, the Black Star Square, it's a very unique design. You can't also make anything like that without seeking permission for it. If you go to Dubai, they have Burj Khalifa. It's a very nice design. You cannot do it anywhere. You go to France, you have the Paris Square. That's wonderful design there. It is unique in the whole world. The same time, if you go to London, they say they have the London Eye. It's a wonderful design nobody else in the world can make. So these are how designs are protected. Beyond mobile phones, even clothes, your beautiful clothes that you are wearing. Whoever that designed, the fashion designer that made your shirt and my smock I'm wearing or fugu I'm wearing, the design of it can be protected by law. You can go to Registrar General's Department, go with your diagrams and to prove that this is a design which never existed. And I, Binoska, have made it all, Mex made it all, Felix also made it. So this is how we protect design. Then the last thing we want to talk about is copyright. Copyright basically means in history, we used to write everything by our hands. There was no means of making photocopies. And so when people had ideas of how to create this, how to write books and story, if you have a book and you want to sell 100 copies of your book, you have to sit down by yourself and write every word in the book. And when you finish, then you pick the first book you have written and recopy it again. So to be able to copy yourself, that is why it is given as copyright. So when you make a movie, when you make a song, when you make a fashion design clothes or anything which of expressive, either artifacts like sculpture, paintings, drawings, computer software codes, and what do you call it, folk songs, and all that exists within our intangible space of copyright, the person who created it first is the only person who has the right to copy again. So for example, I have made, in the beginning, it used not to have separations. It used to be just the law of monopoly that protect everything. But with time, they found means to be able to separate patent from trademark, from design to copyright. So copyright basically means that whoever created that idea or that finished product is the one that has the right to copy himself. And so in law, we have established the Copyright Office, that the Copyright Office in Ghana or anywhere in the world, you go there, you have the means to register your copyright. But because copyright is so vast, it exists in books, in movies, musics, and all artistic and literary works. By international convention, we have something we call the Berne Convention of 1886. This Berne Convention of 1886 made it that every copyright should be all automatically. It means you don't need to register before you have the right. But some countries rectify this law in their country and put another clause. For example, if you go to United States of America, they say that if you don't register, don't go to court to fight battle over it. But so many other countries, they just rectify the Berne Convention and made their own Copyright Act to be the same, that whether you register or you don't register, copyright is automatic. Have it. So if you create a book, if you write a book, you create a song. Once the song or the book or whatever you have created, which is copyright eligible, becomes public, or you have published it for everybody to know, then it means you have the copyright. So once somebody picks that song or that book, make photocopies or whatever it is, and you find the person, you can take them to court, and the court will listen to you because it's automatic. You don't need to register. But the Ghanaian law also come up with this clause that if you want to seek a certificate to show the whole world that Mex wrote this book or made this song, or Felix wrote this, directed this movie, and then therefore you can register to get a legal license. But the law also says that registration does not confer ownership. It only seems to acknowledge that Binoska wrote this book and therefore he has been given the license to be able to distribute, perform, and do whatever he wants to do with it. So this is the three laws that, the three dimensions of the intellectual property and how to protect it. Now, on the question of can you sell these intellectual property that you have? Yes, of course, you can sell. If it comes to patent, if you have registered and you are the rightful owner, you can sell it. If it comes to trademark and you want to change the ownership, let's assume that the owner of Upright Music tomorrow wants to sell the Upright trademark to somebody else, to me, let's say to me, Biska, or to Max, or to you. Then you go in a negotiation, you buy it, and then when you buy it, he can no longer use the Upright Music apart from you, the Upright logo. And the same goes with designs, and it goes with copyright as well. So this is how you can protect it and you can sell it to make money out of it. At this point, I want to invite you to also come up with your questions. We began with the introduction of the ladies first. Yeah. So this time, let's go to the gentleman. First question from you.
Okay. When you were giving us the information about IP, intellectual property, you mentioned monopoly and how it was separated from patents and copyright and stuff. Can you explain that? Can a person presently have that kind of monopoly that has been separated?
Okay. All right. So basically, those times in United Kingdom, they were the people who developed intellectual property laws all around the world. So the monopoly they established was that if you create anything, the law says that you have the monopoly. So let's assume that you are able to create a new sword. Nobody has ever created that particular sword before. The law gives you 7 years alone to create that law, to create that sword or whatever device you have brought. Then after 7 years, you are given an apprentice, somebody to learn the trade from you. So for another 7 years to study with you. When you finish, you bless the apprentice to also go and start making the same thing. That is monopoly. But with time, when industrialization began to come in, they realized that the monopoly was becoming so difficult, because if we have to rely on one person next producing one sword for the whole country, it means it's going to be difficult for that one person to keep producing swords when we all need it. So the law was liberalized, and so they began to now make it different, so that not one person can have that one monopoly. But once you create it, you can register it, and then you have a license to also grant other people license to make the same thing. That is why the word monopoly no longer exists. But these days, even if you register your work, you still have the monopoly, because if you come up with any invention, you still own that invention until you decide otherwise. And that is what it means. And by law, patent lasts for 5-10 years, and then renewable every year till 20 years, then it's gone. That's patent. Trademark exists forever as long as you keep renewing. So, for example, Upright Music, every year you need to every 2 years you need to renew. Once you register the first time, you have 5 years, and then you renew, like that. But music, which is copyright, and it's movie, music, artistic, and literary works and all that, they exist the lifetime of the person who made it. So, for example, Binoska, I've made a movie, I've made a song, I've done an artwork, I've done a drawing, a painting, or whatever. And then, as long as I'm alive, if I live to be 150 years after I die, then they have to calculate 70 years after my death. After 70 years, then that thing that I made becomes public domain. So that is what it means by copyright, the monopoly system. So the monopoly exists in its way, just that we don't have any law that says this is monopoly. Right.
Whilst you were saying that, something just popped into my head. So you said after you have died, after 70 years, then
Yes.
it becomes public. So when it becomes public, does somebody else register for it?
Okay. If it becomes public, you can't go and register, but what you can do is, before the 70 years, you cannot do a cover version. You cannot produce that particular book, like in terms of photocopy, and be selling the same book again. You can't. You cannot use the, a song for advert without seeking permission from the person. You can't. But when the person died and 70 years has passed, then you can pick that song, use it for any advert, use it for anything you want, and nobody can ask you anything. Or, for example, you have a book written by Let me quote one author who has died so many years ago, George Frederick Handel. He made a lot of songs. Or Mozart. People have heard a lot of Mozart. So once Mozart made his songs, and the songs, Mozart has died over 150 years ago, you can pick that book and also make copies and sell. That is what it means by that. But as long as the person is alive and 70 years, or maybe he's dead and 70 years has not passed, it means the song or the work he created has not fallen in the public domain. So public domain simply means that all literary or artistic works which have expired their copyright duration. It means the author has died and 70 years has come. I hope I've answered.
Yes, and another question.
Good.
So, how do you know the lifespan of the person who has actually produced that thing?
Okay.
And do we have in Ghana now, do we have like a place you can go to check all those ones that have expired and are their public domain now?
Okay.
And besides that, if somebody steals your product, your patent, your trademark, and in Ghana especially, you know, people just take books from anywhere. They can just go and print. People have done their books and they are selling them online and all that. But in Ghana especially, people can just pick anything out of anywhere and say they are doing it or they are selling it. Meanwhile, they've not asked for permission from that particular person before you.
Okay.
So how do you solve these issues?
Okay. All over the world, I don't want to say Ghana. I travel all over the world. It is not unique to Ghana. There's no one place you can go and find whether this work has fallen into public domain or not. Once you identify any material, whether song, movie, book, or whatever, artwork, paintings, drawings, sculpture, whatever, it is up to you to find the person. That's what the law says. Find that person to know. Sometimes you may even find the person and the person will say, oh, I give you written permission, go ahead and use it. So that's what it means. There's no one place to find. You can't go to Copyright Office and to go, let me go and find out whether Copyright Office has documentary that what do you call it? The man who, Nana Champon or whatever. I want to mention somebody who is dead. Kakeku died long time ago. I want to go and find out if the time Kakeku died, his song have fallen into public domain. No. You can't do that, and they don't have that record, and by law they cannot do that. All over the world you can't do. Once you find the song or whatever you want to reproduce or make advert about it or make whatever, you need to find the owner or the right owner. Maybe the person has died, the grandchildren, whoever that is inherited it. So it brings us also to the point that intellectual property is inheritable. Just like houses are inheritable, cars and other products, they are also inheritable. So the person who has inherited it, you have to seek permission from them. Now, on the issue of people making photocopies and all that, if somebody is making somebody's photocopy and book, you as a third party, meaning you who don't own that, you can't complain about it. It is up to the owner to go to court or go to police station to report that this my book I wrote. The title of my book is Binoska, or Intellectual Articles of Serendipities. That's one of my books. And then I would now say that I am the rightful owner. Megs is making photocopies of my book, so arrest her. Then when we go to court, you can have a witness, because every issues that has bothered with intellectual property is by two things. It's a crime. At the same time, it's a civil offense. So if it's a crime, it is the state versus Megs. If it's a civil offense, then it is me, the individual, who is filing the case, seeking remedies from you. So nobody can determine whether this has been stolen or not. It is up to the owner. Your question?
Yeah, I definitely have. I have one question. It's after 70 years when an individual dies. And most individuals work with companies.
Yeah.
For musical artists, they mostly work with record labels.
Yeah.
With something like that, what would you say is the duration?
For record labels, if, for example, you make a song or you directed a movie or whatever you did, and the record label signed you on what we call a 360 deal, it means they have taken all your rights away from you. Okay? When that happens, it means the record label owns your work for the first time they publish, they make it public. 70 years. After 70 years, it becomes public domain.
Okay, so it's the same duration for individuals as
Yes.
for companies.
Yes. For company. For example, let me use example, the Methodist Church made a Methodist hymn book and they published it the first time ever in 1931. Up to 2024, the book has fallen into public domain because it has passed 70 years. So anybody can pick the hymn book and sing it and blah, 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 and nothing will happen. Yeah. So that's what it means. But for individual authors, let's assume that the two of you write a book together or create a music together, and then you have not sold your right to any record label company, but you still own your rights. Yes. So the law says that the last surviving author, 70 years will be calculated from the last surviving author. So let's assume that one died today, and then the last one will die, let's say 50 years to come. That 50 years, it is that after 50 years, the last author dies, that we are going to start to calculate 70 years.
Okay. So based on the other party.
Yes. So if it is 4 people who created that one work, the last person who will die, that is the day they will start to calculate the 70 years. Yep.
Most people don't really see the significance of intellectual property, like, and in the culture that we are here. How would you say a person can really benefit from intellectual property? Because let's say somebody does a song, or they do a book, or a creative work, and they feel like, okay, I own it, so that is just it. What would you say is the benefit? I mean, besides stealing, that should make a person want to register.
All right. So the benefit with this is these days ideas are changing. Some people have decided to make works available for people for free, and they don't care whether people infringe on it or not. They don't care whether they want to charge money or they want to do. So all they think is they want to be made popular. They want to be known everywhere. And so that they use their name as a trademark for other engagements that they will charge money. So for example, I can give you one example. One artist in UK, Ed Sheeran, began to make his songs live on the internet without any production. He just go on the internet with his guitar and then he start playing his songs. And people began to stream the songs without getting any paid. And then later, he found a producer and then began to record them again. And then now he wants to protect it. So it is up to an individual to decide, do I want to make it free for everybody? Or do I want to start on the day from business? It's an individual choice. Any other question? We've got some few minutes to wrap up.
With the Ghanaian folklore, love all the history stories about Anansi and all that. I don't know, but is it really registered with somebody?
Right. So the law says that folklore, currently the Ghanaian Copyright Act 690, 2005, it was passed. It says that if you need to use any folklore idea or material or whatever, you need to go to the Ghana National Folklore Board Authority to go and seek permission, of which I don't agree. I've always been talking about it. I don't agree because it hampers creativity, and it's one of my research that I do. So I think we need to really look into it, and this will be the time that will be allowed for us. And so let me end by saying that thank you so much for having this session with me. And I'm glad you gave me wonderful questions. And viewers too at home, those of you watching us online, I'm still waiting for your questions. Type them. I will come and look at it and then give you an answer. And if you want specific topic to be treated, please do. This is Binoska. I'm a creative business and intellectual property consultant. And I also teach at the University of Education, Winneba, with the Department of Music Education and the School of Creative Arts. Until then, let's meet again. This is Binoska.